I knew something was wrong the day I found the bright orange violation notice stapled to my front door like a warrant for my arrest. The paper flapped in the November breeze, screaming that I had exactly 72 hours to remove my unauthorized garden gnome, or face a $200 fine from the Meadowbrook Community Homeowners Association. The problem was, I had no idea what homeowners association they were talking about. My name is Blake Lawson, and I had lived in my house on Maple Drive in suburban Phoenix, Arizona, for exactly 3 weeks. The place was a modest 3-bedroom ranch-style home that I purchased after months of searching for something affordable in the scorching real estate market. The previous owner, an elderly gentleman named Mr. Henderson, had been eager to sell and move closer to his daughter in Tucson. The transaction had been straightforward, or so I thought. I yanked the notice off my door and read it again, this time more carefully. The letterhead bore an official-looking emblem with the words Meadowbrook Community HOA, printed in bold letters beneath a clip-art image of houses arranged in a circle. Below that, in smaller print, I saw a name that would become all too familiar in the coming months. Brenda Patterson, HOA president. The gnome in question was a cheerful little ceramic fellow holding a fishing pole that I had placed near my mailbox. My late grandmother had given it to me years ago, and it was one of the few decorative items I had unpacked so far. According to the notice, garden ornaments of any kind violated Section 4.7 of the Community Guidelines and required written approval from the Architectural Review Committee before installation. I pulled out my phone and called the number listed at the bottom of the notice. A woman answered on the second ring with a tone that could freeze lava. Meadowbrook HOA, this is Brenda Patterson speaking. Hi, my name is Blake Lawson. I just found this violation notice on my door about a garden gnome, but I think there has been some kind of mistake. I am not part of any homeowners association. There was a pause, followed by the sound of papers shuffling. What is your address, Mr. Lawson? 4217 Maple Drive. More shuffling. Oh yes, I have your file right here. You purchased the property from Raymond Henderson 3 weeks ago. You are absolutely part of this association, Mr. Lawson, and you are already in violation of multiple community standards. My stomach tightened. Multiple violations. What are you talking about? And I never signed anything about joining an HOA. I would have remembered that. The association is mandatory for all properties within the Meadowbrook community boundaries, Brenda said, her voice dripping with condescension. When you purchased the property, you inherited all existing obligations and requirements. Now, about your violations. In addition to the unauthorized garden ornament, your grass is currently 2 3/4 inches tall. The maximum permitted height is 2 inches. You also have a green garbage bin visible from the street, which violates our aesthetic standards. All trash receptacles must be stored in garages or behind privacy fences when not in collection day. I looked out my front window at my lawn, which looked perfectly normal to me. You measured my grass. I conduct regular inspections of all properties to ensure compliance. You have 72 hours to address these violations, or you will be fined $200 for each infraction. That is $600 total. This is insane, I said, feeling my face flush with heat. I just moved in. I never agreed to any of this. Your agreement is irrelevant, Mr. Lawson. The covenants run with the land. I suggest you read your closing documents more carefully. Good day. She hung up before I could respond. I stood in my living room surrounded by half-unpacked boxes, staring at my phone in disbelief. This had to be a scam. I immediately called my real estate agent, Marcus Chen, who had handled my purchase. Marcus answered cheerfully. Blake, how is the new place treating you? Not great, Marcus. I just got a call from someone claiming to be the president of an HOA saying I owe them money for violations. Did you know about this? His cheerfulness evaporated. And HOA? No, that property was not listed as being part of any homeowners association. I made sure of that because I know you specifically said you did not want HOA restrictions. That is what I thought too. But this woman, Brenda Patterson, she has my address and says I inherited some kind of covenant when I bought the house. That does not make sense, Marcus said. I could hear him typing on his keyboard. Let me pull up the listing again. Okay, yeah, it definitely says here, no HOA, no special assessments. Did you check your title insurance paperwork? Not yet. I will dig through everything tonight. Do that. And if this woman contacts you again, do not pay her anything until we figure out what is going on. This could be a scam targeting new homeowners. That evening, I spread every document from my house purchase across my dining room table. The stack was intimidating. The purchase agreement, title report, title insurance policy, disclosure statements, inspection reports, and various addendums. I started with the title report, a thick document that listed every recorded claim against the property. I scanned through pages of legal descriptions, tax information, and easements. Nowhere did I see any mention of a homeowners association or covenants, conditions, and restrictions. I moved on to the title insurance policy, which specifically listed all exceptions and exclusions. Again, nothing about an HOA. I was starting to feel more confident that this was indeed a scam when my doorbell rang through the peephole. I saw a middle-aged woman with short blonde hair styled in a severe bob. She wore a navy blue blazer over a white blouse and held a clipboard against her chest like a shield. This had to be Brenda Patterson. I opened the door. "Can I help you, Mr. Lawson? I am Brenda Patterson, president of the Meadowbrook Community Homeowners Association. I wanted to introduce myself personally and discuss your ongoing violations. I already told you on the phone, I am not part of your association." Her smile was as warm as a tundra. "Mr. Lawson, I understand that you are new to the community, and perhaps Mr. Henderson did not properly inform you of your obligations. However, ignorance is not an excuse for non-compliance. I have been president of this association for 12 years, and I have seen every excuse imaginable." 12 years. Something about that number struck me as odd. That is correct. I have dedicated over a decade to maintaining the standards and property values of this neighborhood. Now, I came here to offer you a courtesy warning before the fines become official. If you remove the garden gnome, mow your lawn to the proper height, and relocate your trash bin within the next 48 hours, I will waive the penalties this one time. I looked through all my closing documents, I said, keeping my voice level. There is nothing in there about an HOA. Not in the title report, not in my title insurance policy, nothing. Brenda's expression hardened. The Meadowbrook Community CC and Articus were recorded with the county in 2012. They cover all properties within our designated boundaries, including yours. If they were not disclosed to you, that is an issue between you and your real estate agent, not between you and the association. "Show me proof," I said. "Show me the recorded document that says my property is part of your association." She pulled a sheet of paper from her clipboard and thrust it toward me. "This is a copy of the boundary map showing all properties included in the Meadowbrook community. As you can see, your address is clearly within the marked area." I looked at the map. It showed a neighborhood layout with streets labeled and a highlighted boundary that did indeed encompass my property, along with about 30 other houses. "A map you drew is not legal proof. I want to see the actual recorded covenants. They are public record, Mr. Lawson. You can look them up yourself at the county recorder's office. Now, I have been more than patient with you, but my patience has limits. You have 48 hours. She turned and walked back to a white sedan parked across the street, leaving me standing in my doorway with her map. The next morning, I took a personal day from my job as a software engineer and drove to the Maricopa County Recorder's office. The building was a sprawling complex in downtown Phoenix, and I felt lost navigating the various departments until a helpful clerk directed me to the land records section. I need to find any covenants, conditions, and restrictions recorded against my property. I told the woman behind the counter, providing my address. She typed into her computer, her long nails clicking against the keyboard. Okay, let me see what we have. What year did you purchase? This year, just 3 weeks ago. But the woman claiming to be my HOA president said the CC and Articus were recorded in 2012. More clicking. The woman frowned. I am showing your property was transferred to you last month. That part is correct. Let me search for any CC and Articus filed in 2012 that might reference your address or parcel number. She typed some more, then shook her head. I am not seeing any CC and Articus recorded against your specific parcel number. Do you know if there is a subdivision plat that might include your property? I have no idea. How would I find that out? Let me check the chain of title for your parcel. She typed for several more minutes, occasionally pausing to write notes on a pad of paper. Okay, this is interesting. Your property was originally part of a larger parcel that was subdivided in 1987. The subdivision was called Maple Grove Estates. There were CC and Articus recorded at that time, but they expired in 2007 after 20 years. They expired. Yes, the original covenants had a 20-year term with no automatic renewal clause. So as of 2007, your property has not been subject to any HOA restrictions. She swiveled her monitor so I could see it. See here. The CC and Articus document from 1987 clearly states the term limit on page 1. I felt a wave of relief wash over me. So there is no valid HOA that can enforce anything against my property. Not based on what I am seeing in our records. However, let me search for this Meadowbrook community that you mentioned, just to be thorough. More typing. Okay, I do see a filing from 2012 for Meadowbrook Community Association CC and Articus. Let me pull that up. She clicked through several screens, then printed out a multi-page document. Here you go. This is what was filed in 2012. I scanned the document. It listed the same boundary map that Brenda had shown me, covering approximately 30 properties. But as I read further, I noticed something crucial. This says it only applies to properties where the owners signed a voluntary consent form acknowledging the covenants. That is correct, the clerk said. Let me search our records to see if anyone from your address ever filed such a consent form. She typed again, then shook her head. No consent form on file for your property. Without that, these 2012 covenants would not be enforceable against you. Can I get copies of all of this? The expired original CC and Articus, the 2012 filing, and documentation showing no consent form was filed for my property. Absolutely. It will be $15 for copying fees. I gladly paid and left the recorder's office with a thick envelope of documents. I sat in my car in the parking lot and called Marcus, my real estate agent. Blake, I was just about to call you. I spoke with my broker about your situation, and she said you should definitely get a title search done to verify the HOA claim. I just did one better, I said. I went to the county recorder's office myself. Marcus, there is no valid HOA claim on my property. The original covenants expired in 2007, and the new ones from 2012 require voluntary consent that was never given. That is exactly what I hoped to hear. So what are you going to do about this Brenda woman? I am going to send her copies of everything I found and tell her to back off. Be careful, Marcus warned. Sometimes these HOA people can get really aggressive, even when they are wrong. Document everything, and if she escalates, you might need to talk to a lawyer. I spent that afternoon writing a detailed email to Brenda Patterson, attaching scans of all the documents from the county recorder's office. I explained clearly that my property was not subject to the Meadowbrook Community HOA, and that I would not be complying with any of her demands. I kept the tone professional but firm, concluding with a request that she remove my property from her records and cease all contact. I hit send and felt a genuine sense of satisfaction. This nightmare was over before it really began. 2 days later, I found another notice stapled to my door. This one informed me that I had been fined $600 for the violations previously noted, with an additional $100 late fee for failure to comply within the stated deadline. The notice demanded payment within 10 days and threatened legal action if I did not pay. My satisfaction evaporated, replaced by pure anger. I called the number on the notice, and once again, Brenda Patterson answered. I sent you an email with proof that my property is not part of your association, I said, not bothering with pleasantries. Did you even read it? I read your email, Mr. Lawson, and I disagree with your interpretation of the documents. The Meadowbrook community boundaries include your property, and therefore you are subject to our authority. It is not an interpretation. The county has no record of my property ever consenting to your 2012 covenants. You have no legal standing. We will let a judge decide that, Brenda said coldly. You now owe $700 in fines and fees. If you do not pay within 10 days, we will place a lien on your property. You cannot do that. You have no authority. We will see about that, Mr. Lawson. Good day. I immediately called an attorney. Marcus had recommended a real estate lawyer named David Morrison who had experience with HOA disputes. David's office was able to fit me in the next morning. David Morrison was a tall man in his 50s with gray hair and an easy manner that immediately put me at ease. His office in Scottsdale was lined with law books and framed certificates. I spread my documents across his conference table and explained everything that had happened. He reviewed the papers carefully, occasionally making notes. Finally, he leaned back in his chair. Mr. Lawson, you have a very strong case here. This HOA has no enforceable claim on your property. The problem is, that does not mean they will not try to enforce it anyway. She is threatening to put a lien on my house. She can file whatever she wants, but that does not make it valid. However, even an invalid lien can cause you problems if you ever want to refinance or sell. You would have to go to court to remove it, which costs time and money. So what do? I recommend we send this Brenda Patterson a formal cease and desist letter on my letterhead, laying out the legal facts and warning her that any further harassment will result in a lawsuit. Often, that is enough to make these busybody HOA presidents back down. And if it does not work, then we file a declaratory judgment action asking the court to officially rule that your property is not subject to the HOA. We might also add claims for harassment and seek damages if her conduct has been egregious enough. David's letter cost me $500, which stung, but I hoped it would be the end of the matter. The letter was thorough and intimidating, citing specific Arizona statutes and case law. David sent it via certified mail and emailed me a copy. A week passed with no response from Brenda. I started to relax, thinking maybe the legal letter had done the trick. I even put my garden gnome back out by the mailbox as a small act of defiance. Then I came home from work one evening to find my mailbox had been smashed. The metal post was bent at a 45-degree angle, and the box itself was dented and hanging by one hinge. My grandmother's gnome lay in pieces on the lawn. I called the Phoenix Police Department and filed a report. The officer who responded was professional but not particularly optimistic about finding the culprit. Without cameras or witnesses, these vandalism cases are hard to solve. Could be kids, could be someone with a grudge. You have any disputes with neighbors? Just with the HOA president who keeps trying to fine me illegally. The officer raised an eyebrow. You think she did this? I do not know, but the timing is suspicious. Well, I will make a note of it in the report. If you want to pursue this further, you could look into getting a security camera system. Over the weekend, I installed 3 outdoor cameras covering my front yard, driveway, and backyard. I also replaced my mailbox with a heavy-duty model designed to resist baseball bat attacks. The whole thing cost me close to $400. Monday morning, I found yet another violation notice, this time complaining about my new mailbox. According to Brenda, it did not match the approved community aesthetic and needed to be replaced with a standard rural-style mailbox in black or white. I photographed the notice and forwarded it to David Morrison with a note about the vandalism. He called me within the hour. Blake, this is starting to look like a pattern of harassment. Have you gotten any response to my cease and desist letter? Nothing. She is just ignoring it and continuing to send violation notices. All right. I think it is time to file that declaratory judgment action. Based on what you have told me in these documents, I am confident we can win. My retainer for this type of case is $5,000, and the total cost will probably run between $8,000 and $12,000 depending on how much the HOA fights it. The number made me wince, but I was done being pushed around. Let us do it. David filed the lawsuit the following week. The complaint was straightforward. We asked the court to declare that my property was not subject to the Meadowbrook Community HOA, to enjoin the HOA from further harassment, and to award damages for my costs and emotional distress. Brenda Patterson and the HOA were served with the lawsuit, and I waited to see how they would respond. David warned me that they had 30 days to file an answer. In the meantime, life went on. I settled into my house, met some of my actual neighbors, and discovered that I was not the only one dealing with Brenda's antics. My next-door neighbor, a retired teacher named George, stopped by one evening with a 6-pack of beer and a sympathetic ear. I heard you are having trouble with Brenda and her fake HOA, George said as we sat on my back patio. She has been pulling this scam for years. Years. Why has not anyone stopped her? Most people just pay the small fines to avoid the hassle. The ones who push back either move away or eventually give in. I think you are the first person who has actually sued her. How many houses are supposedly in this association? She claims 32, but I know for a fact that at least half of those owners never signed her consent forms. My house is one of them. She tried to fine me about 8 years ago for parking my RV in my driveway. I told her to pound sand, and she eventually left me alone. But I have heard she has collected tens of thousands of dollars from other homeowners over the years. That is fraud, I said. Has anyone reported her to the police? George shrugged. It is a civil matter, not criminal. Or at least that is what the cops told the few people who tried. Unless you can prove she is intentionally stealing money, it is just a contract dispute. The county records prove there is no valid contract. Then you might actually have a shot at shutting her down, A lot of people in this neighborhood will be rooting for you. The HOA's answer to my lawsuit arrived exactly 30 days after service. They hired a lawyer, a woman named Patricia Vance, who apparently specialized in HOA law. The answer denied all of my allegations and asserted that the Meadowbrook community was a valid association with authority over my property. David called me after reviewing their response. They are going to fight this. Their attorney filed a counterclaim alleging that you owe approximately $8,000 in unpaid fines accumulated over 12 years. 12 years. I have only owned the house for 2 months. They are claiming the previous owner, Raymond Henderson, was also subject to the HOA and never paid his fines. According to them, when you bought the property, you assumed his debt. That is insane. How can I owe money for fines issued before I even own the property? You cannot, at least not in any legitimate system. But this tells me they are going to be aggressive. I am going to file a motion for summary judgment, arguing that the undisputed facts show your property is not subject to the HOA. If the judge agrees, we can get this dismissed without going to trial. The legal process moved at a glacial pace. Months passed with an endless exchange of motions, responses, and discovery requests. David requested copies of all signed consent forms from the HOA, all financial records showing fines collected, and all correspondence related to my property. The HOA fought every request, claiming various privileges and objections. During this time, the violation notices kept coming. Brenda found new and creative things to complain about. My house numbers were too small. My front door was the wrong shade of blue. My sprinkler system ran at unauthorized hours. My trash cans were visible for more than 12 hours on collection day. I photographed and documented everything, forwarding it all to David. "This is good for us," David said during one of our check-ins. "It shows a pattern of harassment and obsessive behavior. The judge is going to see this and recognize that she is not acting reasonably." In month 4 of the lawsuit, something interesting happened. I received a letter from the Arizona Attorney General's Office, Consumer Protection Division. They had received complaints about the Meadowbrook Community HOA and were opening an investigation into potentially fraudulent business practices. They asked if I would be willing to provide information and documentation. I immediately called David. "Is this normal?" "It is unusual but very good for your case. If the AG finds evidence of fraud, that could lead to criminal charges against Brenda. At minimum, it adds pressure for them to settle." I provided the Attorney General with everything I had. The county records showing no valid HOA, the timeline of violation notices, the vandalism report, copies of fines demanded, and a detailed statement of events. I also gave them George's contact information so they could talk to other affected neighbors. 2 weeks later, I got a call from an investigator named Sarah Chen. She wanted to meet in person to go over the details. We met at a coffee shop in Tempe. Sarah was a sharp woman in her 30s who immediately struck me as someone who did not miss details. She had already reviewed all the documents I sent. "Mr. Lawson, I want to be upfront with you. This case is more complicated than a typical consumer fraud matter because it involves property law and HOA governance, which are usually civil issues. However, based on what I have seen, there appears to be evidence that Miss Patterson has knowingly collected money under false pretenses from multiple homeowners. That could rise to the level of criminal theft by deception. How many other homeowners has she done this to? We have identified at least 18 properties where she has collected fines, and none of them have valid consent forms on file with the county. We are estimating she has collected over $70,000 in the past 12 years. I let out a low whistle. So, what happens now? We are continuing our investigation. We will be interviewing Miss Patterson and reviewing her financial records. Depending on what we find, we may refer charges to the county attorney for prosecution. In the meantime, has she attempted to collect any money from you directly? She has sent me bills, but I have not paid anything. She did file a counterclaim in my lawsuit saying I owe $8,000. Sarah made a note. Okay. Continue not paying anything and keep documenting all contact. If she threatens you or engages in any intimidation, call me immediately. She handed me her business card. The investigation must have spooked Brenda because the violation notices suddenly stopped. For 2 glorious weeks, I heard nothing from her or the HOA. I started to hope that maybe she would just disappear and the whole thing would resolve itself. Then the HOA's attorney filed a motion to dismiss my lawsuit, arguing that I had failed to exhaust administrative remedies by not appealing the fines through the HOA's internal dispute resolution process before going to court. David was incredulous when he called to tell me. They are arguing you should have appealed fines from an organization you were never actually a member of. It is circular logic at its finest. Will the judge buy it? I doubt it, but we will have to file a response and brief it fully. This is exactly the kind of delay tactic that drives up costs for everyone. David was right. We spent another month and several $1,000s briefing the motion to dismiss. The hearing was scheduled for early March, nearly 6 months after I had first filed the lawsuit. I took time off work to attend the hearing. The courthouse in downtown Phoenix was intimidating, all marble floors and high ceilings. David met me outside the courtroom looking confident in his dark suit. Remember, you do not need to say anything unless the judge asks you a direct question. Let me do the talking. The judge was a woman named Honorable Margaret Fisher. She had a reputation, David told me, for being no nonsense and very smart. Both sides made their arguments about the motion to dismiss. Patricia Vance, the HOA's attorney, stood up and delivered a passionate speech about the importance of homeowners associations and the need to follow proper procedures. When it was David's turn, he calmly walked the judge through the county records showing no valid HOA agreement and pointed out the logical absurdity of requiring someone to appeal to an organization they were never part of. Judge Fisher listened to both sides, reviewed the submitted briefs, and then rendered her decision from the bench. The motion to dismiss is denied. The defendant has failed to provide any credible evidence that the plaintiff was ever properly made subject to the association's authority. This case will proceed to summary judgment on the merits. I am also ordering the defendant to produce all documents previously requested in discovery within 14 days. No further delays will be tolerated. It was a complete victory. As we left the courtroom, David was grinning. That was about as good as we could have hoped for. The judge clearly sees through their tactics. So what happens next? We take depositions, we get their documents, and we file for summary judgment. I would say we are 60 days from resolution, maybe 90. The HOA finally turned over their documents, and what we found was stunning. Brenda had been keeping meticulous records of every fine issued, every payment collected, and every property in her supposed jurisdiction. But cross-referencing her records with the county database showed that only 4 properties out of 32 had ever filed consent forms to join the association. Even more damning, her financial records showed she had been paying herself a monthly management fee of $1,500 from the collected fines. Over 12 years, she had personally pocketed over $200,000. David immediately forwarded everything to Sarah Chen at the Attorney General's office. "This is not just consumer fraud anymore," he told me. "This is organized theft on a significant scale." The depositions were scheduled for late April. I was deposed first, and it was a grueling 3-hour session where Patricia Vance tried to trip me up with technical questions about property law and contract formation. David objected frequently, and I stuck to the simple truth. I had never agreed to join any HOA. I had checked my title documents thoroughly, and I had evidence from the county proving no valid association existed. Brenda Patterson's deposition was a disaster for the HOA. David grilled her for 6 hours, and the transcript was absolutely damning. She admitted she had never verified whether the properties in her boundary map had actually signed consent forms. She admitted she had been collecting money and paying herself without any oversight or board approval. She even admitted that she knew some of the homeowners disputed her authority, but that she fined them anyway to encourage compliance. When David asked her directly whether she had ever confirmed with the county recorder that the required consent forms had been filed, she said, "I did not think that was necessary. The boundary map clearly shows which properties are included." David forwarded the deposition transcript to Sarah Chen with a note. Exhibit A for criminal charges. In May, David filed our motion for summary judgment. The brief was devastating, walking through every piece of evidence and showing conclusively that no valid HOA existed, no consent had been given, and the entire operation was a fiction created by Brenda Patterson. The HOA's response brief was weak, relying on vague arguments about community standards and property values. They could not produce any evidence that I had ever agreed to their authority. The summary judgment hearing was scheduled for June 15th. I marked it on my calendar and tried to be patient as the date approached. Then, on June 3rd, everything changed. Sarah Chen called me with news. The Maricopa County Attorney's Office had filed criminal charges against Brenda Patterson for theft, fraud, and fraudulent schemes. She had been arrested that morning. We executed a search warrant on her home and seized all of her HOA records, Sarah said. We have evidence showing she defrauded at least 23 homeowners out of more than $250,000 over 12 years. She is being charged with multiple felonies. What happens to my civil case? That is up to you and your attorney, but I would expect the HOA's lawyer to withdraw pretty quickly. There is no money left to pay her, and defending Brenda is now radioactive. Sarah was right. 2 days later, Patricia Vance filed a motion to withdraw as counsel for the defendant, citing irreconcilable differences and non-payment of fees. The motion was granted. Brenda Patterson, now representing herself, sent David a rambling email asking to settle the case. She claimed she had been misunderstood and was just trying to maintain neighborhood standards. She offered to dismiss all claims against me in exchange for me dismissing my lawsuit against her. David laughed when he showed me the email. She is facing felony criminal charges and still thinks she can negotiate. I am going to tell her we will accept nothing less than a full admission that the HOA has no authority over your property, payment of all your attorney's fees and costs, and a permanent injunction against her ever contacting you again. Brenda never responded to David's counteroffer. The summary judgment hearing went forward as scheduled, with Brenda not bothering to appear. Judge Fisher granted our motion in full, issuing a declaratory judgment that my property was not and had never been subject to the Meadowbrook Community HOA. She also awarded us attorney's fees and costs totaling $14,000 and issued a permanent injunction prohibiting Brenda or anyone acting on behalf of the HOA from contacting me or entering my property. The criminal case moved forward through the summer. Brenda initially pleaded not guilty, but in September, she changed her plea to guilty on multiple counts of theft and fraud as part of a plea agreement. At her sentencing hearing in October, the judge gave her 4 years in prison and ordered her to pay restitution to all the victims she had defrauded. I attended the sentencing hearing along with several other homeowners who had been scammed. When the judge asked if anyone wanted to make a victim impact statement, I stood up. "Your Honor, Brenda Patterson put me through hell for almost a year. She vandalized my property, harassed me constantly, and cost me thousands of dollars in legal fees to defend myself against an organization that never had any legal authority. She did not do this because of an honest misunderstanding. She did it because she enjoyed the power and the money. She hurt a lot of people, and I am glad she is being held accountable." The judge nodded solemnly. "Thank you, Mr. Lawson. The court appreciates your statement." After Brenda was led away in handcuffs, several of the other victims approached me in the hallway. They thanked me for standing up to her and for having the resources to fight back. One older woman told me she had paid Brenda over $15,000 in fines over the years because she was afraid of losing her home. "I wish I had known it was all fake," she said, tears in her eyes. "I could have used that money for so many things." The restitution process took months to sort out, but eventually, I received a check for the full $14,000 in legal fees that Judge Fisher had awarded. Brenda's house was sold to pay back the victims, though most people only recovered a fraction of what they had lost. As for my house, I finally felt like it was truly mine. I planted flowers in my front yard, installed a new decorative mailbox that Brenda would have hated, and put up 3 garden gnomes near my front walkway in honor of my grandmother. George from next door came over one evening in November, almost exactly a year after this whole ordeal started, and we sat on my patio drinking beer and watching the sunset. "You did a good thing," George said. "A lot of people in this neighborhood were too scared to stand up to her." "I just wanted to be left alone in my own house," I said. "I could not believe someone could get away with that kind of scam for so long." "Well, she is not getting away with it anymore, thanks to you." I looked out at my backyard, at the garden I had spent months cultivating, at the home I had fought so hard to keep free from illegal interference. The whole experience had been exhausting and expensive, but it had taught me an important lesson about standing up for yourself and not backing down when you know you are right. My property was never under Brenda Patterson's authority, despite her claims and her threats and her 12 years of running her fraudulent scheme. The title search proved it, the county records confirmed it, and now a court had declared it officially. Sometimes the system works the way it is supposed to, but only if you are willing to fight for it. I raised my beer bottle in a silent toast to my grandmother, whose little fishing gnome had started this whole mess. She would have been proud of me for standing my ground. And as I sat there in the fading light, I felt a deep sense of satisfaction knowing that Brenda Patterson would never be able to harass another homeowner again. The following spring, I organized a neighborhood barbecue and invited everyone on the street. Nearly 40 people showed up, and for the first time, we all got to know each other without the shadow of Brenda's fake HOA hanging over us. People shared stories about their experiences, some funny and some infuriating. One guy named Tom told us that Brenda had once fined him for having the wrong brand of roof shingles. Another woman, Jennifer, said Brenda had threatened to foreclose on her house over unpaid fines for having a flagpole. "How did you deal with it?" I asked Jennifer. "I ignored her," Jennifer said. "My husband is a lawyer, and he told me she had no legal standing, but I know a lot of other people who just paid to avoid the stress. As the evening wore on and the stories piled up, I realized just how many lives Brenda had negatively impacted. It was not just about the money, though that was significant. It was about the stress, the fear, the feeling of being powerless against someone who seemed to have authority but was really just a bully with a clipboard. My experience became something of a neighborhood legend. New residents would sometimes knock on my door to ask about the HOA situation, having heard rumors or found old violation notices in their closing documents. I always took the time to explain what had happened and to show them the court documents proving there was no valid association. I wanted to make sure no one else fell victim to a similar scam. The house itself became my sanctuary. I spent my free time fixing it up exactly the way I wanted, without worrying about whether some busybody would approve of my choices. I painted the front door a deep red color that I loved. I installed solar panels on the roof. I built a workshop in the garage and took up woodworking as a hobby. Every improvement felt like a small act of rebellion against the tyranny Brenda had tried to impose. In December, almost 14 months after this whole saga began, I received a letter from the county attorney's office informing me that Brenda's restitution payments had been processed and that her case was now closed. She would serve her full sentence and then be on probation for 3 years after release. The letter thanked me for my cooperation in the investigation and prosecution. I filed the letter away with all the other documents from the case, a thick folder that represented one of the most stressful periods of my life. But I had survived it, and more importantly, I had won. David Morrison called me a few days before Christmas. "Blake, I wanted to let you know that I am using your case as a teaching example in some HOA law seminars I am doing. It is a perfect illustration of why proper title work is so important and how HOA authority is not automatic." "I am glad some good came out of it," I said, "more than you know." I have had 3 other clients come to me with similar situations after hearing about your case. These fake HOAs are apparently more common than anyone realized. You helped expose a real problem. That made me feel better about the whole ordeal. Maybe my fight had not just been about me and my garden gnome. Maybe it had helped other people too. As I hung up the phone and looked around my living room, now fully unpacked and decorated for the holidays, I felt a profound sense of gratitude. Gratitude that I had the resources to fight back, that I had found a good lawyer, that the legal system ultimately worked, and that justice had been served. I never saw Brenda Patterson again after her sentencing hearing. I heard through the neighborhood grapevine that her husband divorced her while she was awaiting trial, and that her adult children had cut off contact. She had lost everything in pursuit of power and money that was never rightfully hers. Sometimes late at night, when I am sitting on my back patio looking at the stars, I think about what might have happened if I had just paid those first fines. It would have been easier in the short term, just $600 to make the problem go away. But it would not have made the problem go away, not really. Brenda would have kept coming back with more demands, more fines, more violations. She would have controlled my property and my peace of mind for as long as I lived there. By standing up to her, by doing the research and hiring the lawyer and going through the grueling legal process, I had not only protected myself, but helped dismantle a fraudulent operation that had been hurting people for over a decade. That meant something. The house on Maple Drive was not just my home anymore. It was a symbol of what happens when you refuse to be bullied, when you demand proof instead of accepting claims at face value, and when you are willing to fight for what is right even when it is difficult and expensive. I thought about all the people who had paid Brenda's fraudulent fines over the years, good people who were just trying to avoid conflict, or who did not know they had the right to say no. I thought about the system that had allowed her to operate for so long, the gaps in oversight and enforcement that made it possible for someone to create a fake organization and extort money from their neighbors. But I also thought about the people who had helped me. Marcus, my real estate agent who immediately knew something was wrong. David, my attorney who fought tenaciously on my behalf. Sarah Chen and the other investigators who took the case seriously and built a criminal prosecution. Judge Fisher, who saw through the HOA's tactics and ruled fairly. And my neighbors like George, who supported me and shared information that helped build the case. The experience changed me in ways I had not expected. I became more involved in local government, attending city council meetings and learning about the regulations that governed HOAs and property rights. I even testified before a state legislative committee that was considering new laws to increase oversight of homeowners associations and prevent fraud. The new laws that eventually passed required all HOAs in Arizona to register with the state, maintain proper financial records subject to audit, and provide clear notice to homeowners about their rights to challenge fines and fees. The legislation was nicknamed Brenda's Law by the media, though officially it was called the Homeowner Protection Act of 2025. When the law passed, I received calls from several reporters wanting to interview me about my experience. I did a few interviews, always emphasizing the same points. Do your research, check your title documents, do not assume someone has authority just because they claim it, and fight back when you know you are right. One of those interviews led to an invitation to speak at a real estate conference in Las Vegas. I was terrified of public speaking, but I accepted anyway. Standing in front of 200 real estate professionals and attorneys, I told my story from beginning to end. The audience was rapt, and afterward, dozens of people came up to share their own HOA horror stories or to thank me for raising awareness about the issue. That speaking engagement led to others, and I found myself becoming something of an accidental advocate for HOA reform. It was never something I planned or wanted, but it felt important. If I could prevent even one person from going through what I went through, it was worth the time and effort. My software engineering job remained my primary career, but the advocacy work became a meaningful side project. I created a website with resources for homeowners dealing with questionable HOA claims, including a step-by-step guide for how to research your property's title and what to do if you suspect fraud. The website got thousands of visitors in the first month alone, and I received emails from homeowners all over the country dealing with similar situations. While most legitimate HOAs operate properly and provide real value to their communities, the bad actors like Brenda Patterson give all of them a terrible reputation and cause real harm to real people. Looking back on everything that happened, I sometimes wonder what would have occurred if I had chosen a different house, if Mr. Henderson had not been so eager to sell, if I had not happened to have a grandmother who gave me a garden gnome. The randomness of it all was striking. But I also believe that things happen for a reason, and maybe I was meant to be the person who finally stood up to Brenda Patterson. The financial cost of fighting back had been significant, nearly $15,000 in legal fees before the restitution payment. The emotional cost was harder to quantify but equally real. The stress of the lawsuit, the violation notices, the vandalism, the constant feeling of being under attack in what was supposed to be my safe space, all of it took a toll. But the alternative, living under the thumb of a fraudulent bully who would have continued to harass and extort me for as long as I owned the property, would have been far worse. Some things are worth fighting for, and your home is one of them. As the seasons changed and I approached my second anniversary in the house, I reflected on how much had happened in such a short time. I had gone from excited new homeowner to legal combatant to accidental activist, all because I had the audacity to put a garden gnome in my yard. The 3 gnomes that now adorned my front walkway, each one slightly different and representing a different stage of my journey, had become a neighborhood landmark. Kids would point at them as they walked by, and visitors always asked about them. I was happy to tell the story, edited for younger audiences. My relationship with my neighbors had deepened through this shared experience. We looked out for each other now, checking in regularly and maintaining a group chat to share information and concerns. The neighborhood felt like a real community in a way I had not expected when I first moved in. I dated occasionally, and the HOA story always came up. Some people thought it was fascinating, others found it stressful just hearing about it. One woman I went out with a few times told me I had trust issues because I insisted on checking all her online dating profile claims against public records. I did not see her again after that, but she might have had a point. Work continued as normal, writing code and attending meetings and dealing with the usual corporate challenges. But my experience with Brenda gave me a different perspective on conflict. I was less willing to back down when I knew I was right, more insistent on documentation and proof, and quicker to escalate issues when people tried to bluff or bully their way through problems. My boss noticed the change and actually appreciated it. "I do not know what happened to you over the past year, Blake, but you have become a lot more assertive. It is a good look on you," he said during my annual review. The garden gnome that started it all, or rather its replacement after the original was vandalized, sat in a place of honor in my living room on the mantel. I had ordered an exact replica online and kept it indoors as a reminder of why I fought and what I won. The outdoor gnomes could weather the elements, but this one was special. Sometimes friends would ask if I regretted buying the house, given everything that happened. The answer was always no. I loved my house. I loved the neighborhood. I loved the sense of accomplishment that came from standing up for myself and winning. None of that would have been possible if I had chosen an easier path. The title search that David had ordered at the beginning of the case, the one that definitively proved my property, was never under HOA authority, hung framed in my home office. It was a boring legal document full of technical language and property descriptions. But to me, it represented truth defeating lies, evidence defeating claims, and justice defeating fraud. I thought about Brenda sometimes, sitting in prison and contemplating the choices that led her there. Did she feel remorse for what she had done, or did she still believe she was in the right? Did she understand that her desire for control and money had destroyed her life and hurt so many others? I would never know, and honestly, I did not need to. Her story was over, at least as it related to me. My story, on the other hand, was just beginning. The house on Maple Drive was not just where I lived. It was proof that ordinary people can fight back against injustice and win. It was evidence that doing your homework and standing your ground matters. It was a testament to the importance of property rights and the rule of law. As I sat on my patio that December evening, exactly 2 years after finding that first violation notice on my door, I raised a glass in silent tribute to everyone who had helped me along the way. The journey had been difficult, but the destination was worth it. I was home, truly and legally home, and no one could take that away from me. The garden gnomes stood watch over my front yard, cheerful and defiant, exactly where they belonged. And somewhere in a filing cabinet at the Maricopa County Recorder's office, the official records showed the truth that I had proven. My property at 4217 Maple Drive was never, and would never be, under the authority of the Meadowbrook Community Homeowners Association. That truth had cost me time, money, and stress to establish, but it was worth every penny and every sleepless night, because in the end, justice prevailed, the fraudster went to prison, and I got to live in peace in the home I had worked so hard to buy. And really, that was all I had ever wanted.